Hey guys, Seth Fuller, your favorite attorney and your Texas trial champion here. Today I'm going to talk about a recent $46 million judgment against a Brazilian Jiu-Jitsu studio and instructor. You heard that right, $46 million. Now, if you're watching this, this is the short version. If you're a nerd or you just like long-form conversations, it's, to me, very interesting. It's an hour long. Go check that out. It will just be the long form version of this on my channel. This particular video is about 30 minutes and it's a conversation between me and my colleague and friend Mike Parker, mrparkerlaw.com, Mr. Parker Law in Los Angeles. If you're in California, he's a great attorney and he talked with me about the things I didn't know about personal injury, specifically in California where this lawsuit takes place. Now, as for the lawsuit, this is about a young man named Mr. Rener, and Mr. Rener was a Brazilian Jiu-Jitsu competition white belt, and he was going to classes at Del Mar Jiu-Jitsu Club, which one of my black belts that I'm friends with and trained under actually taught at for a while. In any event, in November of 2018, Mr. Rener was injured while rolling with a black belt. One of the instructors, Mr. Francisco Sinistro Iturralde, and basically there was a lawsuit. There was experts on both sides, and the result was the jury found a $46 million judgment. The Brazilian Jiu-Jitsu community said, oh, the instructor is terrible, and brought out the pitchforks against the instructor. Then the video came out, which then they brought out the pitchforks against the jury, and then and Rener Gracie, who was the expert on the plaintiff side, and then Rener Gracie made a video, and the pitchforks all went against each other. In any event, I think this explains everything perfectly and gives a good explanation of everything and a good criticism of the what I feel are the correct criticisms against Rener Gracie. Now, to start it off, I'm going to show an edited version because this is the shorter monetized version of this, and I don't want it to get censored, and I want more people to see this version because it's a summary. And so I'm going to show the edited version without the injury itself of the video, and then we'll go into the conversation. If you go watch the longer video, it has the full video unedited, and you can kind of see a little better explanation. In any event, thank you for watching, and I hope you enjoy it. So basically, can you break down, this is a standard personal injury lawsuit, similar to what you might see in a slip and fall in a business, correct? Which is someone got injured. This is not criminal, so the intent is totally different. You don't even have to have intention, just like most car accidents. Most car accidents, there's no intent to get in the car accidents. Do you agree with me?
Yeah, I mean, I think what people don't realize is that this whole situation was probably a mismanagement by the insurance company, right? And I haven't seen any articles that talk about this, right? But you would have never heard about this case if some adjuster somewhere didn't screw up really badly. So what happened is the referring firm probably sent a policy limit demand after the accident to the insurance company. And the adjuster who evaluated that case probably did not pay the policy limits. Now, if an insurance carrier is presented an opportunity to settle within policy limits, and it's reasonable that they should settle within policy limits, and they don't, and then the plaintiff goes after the defendant for an excess verdict or personal contribution, then the defendant could have a bad faith claim against the insurance company. And then if you go to trial as a plaintiff and you win money in excess of the policy, that defendant can assign you their bad faith rights in exchange for you not collecting against them.
Let me stop and clarify real quick about that. So basically, to summarize, what you're saying is that again, the reason we have insurance, any of us have business insurance, is for an accident like this, any accident where someone gets injured. Hey, that person's just not stuck out a quadriplegic with no help doing
Exactly.
GoFundMe.
Yeah.
So again, this isn't necessarily, oh, it's terrible for the business owner. Well, then you hear, well, but $46 million, $42 million, whatever it is, millions of dollars, how is that possible? But essentially what it is if I have $1 million worth of insurance, you give a demand for $1 million, basically.
Correct.
And then that insurance company can say, okay, that's fine. This kid is way more than $1 million in damages. We're going to give you the $1 million. And then you're done and you go away. The kid gets, 2/3 of $1 million usually because the lawyer takes a third. But basically everybody's happy.
And I've done this before where we make a policy limit demand. They don't pay the demand. And then we get above the policy limits from the insurance company because they acted in bad faith. I've gone to trial on cases, I've gotten above policy, and the insurance company paid. But what probably happened here is you get a cocky adjuster. They say, this is stupid. This is, a physical activity the guy signed up for. This guy signed a waiver. He assumed the risk, and we're not going to pay a dime because we think that either a jury is going to give us or give the plaintiff nothing, or we're going to win on what's called summary judgment. And summary judgment is a motion you can file in court which says, based on the facts, if you accepted them all as true, there's no case essentially.
So now they say, instead of paying the $1 million, which they could do, that's why I buy insurance. And I want, again, even if it's not my fault, I still want this kid to get money for his medical bills, even if it was an accident. So me as a business owner, as an insurance policy holder, I want them to pay. I just want them to give the kid the $1 million and leave me alone. I don't want to pay it, but I don't want to pay it.
The insurance company has a duty to protect their insured. That's the duty of good faith, right?
So the reason they have this rule the reason they have this rule that you're talking about is because then the insurance company should pay the $1 million. If they don't, what then happens there in California, it's different in every state.
Sure.
But essentially, the law office who won the $46 million settlement, they know this gym owner don't have anywhere close to that. So what they do instead is they have him sign basically a contract or an agreement saying, we're not going to come after you. We're going to come after the insurance company. And then they sue the insurance company, who may have to pay the $46 million if they're found to have acted in bad faith by not settling the $1 million. Essentially, this gym owner and this black belt jiu-jitsu instructor are probably not out any money. Probably not almost any money, maybe some legal fees for themselves or something. But again, most of that, probably not.
The gym owner might even potentially get money because the gym owner might have his own bad faith case against his own carrier. But I think it's important for people to understand, they see these big numbers, 46 million, and they think, who's going to pay it? How are they going to pay it? Is it going to ruin the gym owner's life? And I think it's important to realize the insurance company screwed up and they're the ones who are going to pay it. But going back to the waiver. So in California, you can waive negligence, right? And I think this is where the adjuster probably messed up, right? But you cannot waive what's called gross negligence. So negligence is just the departure from the ordinary standard of care. You're driving your car, you look down to change the radio, you look up and you rear end someone. That's ordinary negligence, right? But gross negligence in California cannot be waived. And that is the extreme departure from the ordinary standard of care. So for example, if I'm a waiter at a restaurant and I'm running full speed, carrying a knife, and I accidentally stab someone, that's a gross, departure from the ordinary standard of care. And in this instance, my personal opinion is I don't think it was gross negligence. I think this is just, an accident that happened that was ordinary negligence. But you have to understand that normal jurors are not jiu-jitsu practitioners. I've done jiu-jitsu for, 13, 14 years. I know that I've, had my arm overextended in an arm bar. I've been choked nearly unconscious by someone who doesn't hear me, or feel me tap. Right? It's just part of, the normal course and scope of doing this activity. But the ordinary person on a juror is going to hear jiu-jitsu master black belt, high-level competitor, did a dangerous move and didn't do it right. And they're not going to understand that when you're doing jiu-jitsu, there's a lot going on and mistakes are made. And that's how you learn. You learn by doing things wrong. So there's a lot of risk there. So I could see how a jury could find that there's gross negligence, or a judge on a summary judgment motion could find that there's gross negligence. But in my personal opinion, I would say it was ordinary negligence. But still, the adjuster has to understand that there's that risk there, that, in a high level activity where there's a catastrophic injury, that the waiver might get thrown out. And to be honest, the more serious the injury, the more likely people are going to let it slide that there's a waiver, because a jury or a judge is going to feel sympathetic that they're not going to want to deprive this really injured person of a lot of money simply because they signed a waiver.
I think that's a really good point, and that goes to kind of what we're talking about, which is everyone's grossed out about this. But in the end, what I'd like to summarize for people about this justice system is this may come down to the only person who is out is the insurance company that you pay to make sure that you aren't out money. So the only people who are out is this multi-billion probably dollar company that, or at least multi-hundreds of $1,000,000 company that should know better, and we pay every month, everybody pays to mitigate this risk, and they're going to be the only ones out, and the only ones benefiting besides the attorneys, which we're okay with, the only ones really benefiting is going to be the young man who was paralyzed
Correct.
through doing a hobby that he enjoyed. Well, you got to find out what happened to the waiver, because I want to talk about that real quick. Everybody signs a waiver. There's also this thing called implied waiver.
Well, I don't know in Texas, right, where you are, what the rules are with waivers. But what I can tell you in California is there's no way to absolutely protect yourself if you run activities that are physical, right? If you have a rock climbing gym, if you have a, jiu-jitsu school, if you have a fencing school, right? You can have waivers for ordinary negligence, but you can absolutely not waive gross negligence in California. And the truth of the matter is that the more serious the injury, the more likely that the waiver will get thrown out and it'll be classified as gross negligence, right? And kind of the reason is like I said, judges and juries tend to have more sympathy for someone who's seriously injured, but also the kind of activities that seriously injure people just seem more extreme, right?
From what I understand, the judge would only throw it out before the jury would generally be able to at least hear about the waiver. It got thrown out is what I understand. So
so there was probably a motion for summary judgment, and I'd have to go look at the docket to find out. But my guess is there was probably a motion for summary judgment. The school or the carrier for the school and the defense firm they hired probably said, we have no liability because we have an absolute defense, which was there was a waiver of negligence. And then the judge probably found that, hey, there was gross negligence and based on the facts that were presented, and I'm not going to grant your motion for summary judgment. It's going to be denied. And then it goes to a jury who is going to hear basically the facts of the case.
All right. So me and you both watched the video. We're both regular practitioners of Brazilian Jiu-Jitsu. We watched that video. Again, I think looking at Reddit BJJ, r/BJJ, there's no doubt everyone thought the same thing, which was while looking at this video, this is something that could have happened at any gym between any two sparring partners. This was not an unusual occurrence, what we saw. You would agree with that?
Oh, 100%. Like I said earlier, I've been injured so many times training, and sometimes it's been by white belts who are just over aggressive, but I've also been injured by black belts too when they just mess something up. Jiu-jitsu is like chess. It's a constant learning process, right? You're always going to get better. Even if you're even doing it for 30 years, there's always something to learn. And the only way you learn in jiu-jitsu is by practicing in live sparring. And when you practice in live sparring, you're gonna mess things up, and sometimes people get hurt. But what I'll tell you is everyone understands who practices jiu-jitsu that getting injured is part of the learning process, both for you, but also for the person who's learning on you.
I think everybody who does Brazilian Jiu-Jitsu and who's in the community agrees that this was simple negligence.
Oh, I agree. But you have to understand, as an insurance company, and this kind of goes back to what I was saying, the adjuster put the risk on their insured basically that the court would agree or a jury would agree that this was ordinary negligence. And you have to understand, most people who evaluate this aren't jiu-jitsu practitioners. There are
Yes.
people who are going to hear master jiu-jitsu guy and he messes up and injures someone.
And more importantly, and I think this is what a lot of people want to hear, and I think this is kind of like the silver lining that I'm trying to get, which is if it was simple negligence, probably it gets thrown out as summary judgment, and this kid gets no money.
Yeah.
And again, some would say, well, that's the law, that's how it works, and that's how the insurance company deal with it, and my insurance company shouldn't have to face it if under the letter of the law it is simple negligence, blah, blah, blah. But in the end, if it's simple negligence, the short answer is this kid probably gets zero, nothing.
Yeah. I mean, here's what I'll tell you. Honestly, this case is good for jiu-jitsu practitioners. And I know people don't want to hear it. It's good because when people get in catastrophic, serious injuries now in jiu-jitsu, the insurance companies are going to take these cases seriously. So if someone gets injured, right, and they break their leg or break their neck or, have some sort of brain injury, right, the insurance carriers now, the adjusters are going to remember this case. And they're going to pay that $1 million policy, make sure the person's taken care of right away. And, this case was from 2018. It's 2023 now. This kid had to fight for 5 years to get paid, 5 years to get help, 5 years to get justice. And I think this is going to help, all practitioners, because it's going to make it so insurance carriers take these injury cases more seriously, do their job at both protecting the school, but also, getting money to people who are seriously injured. The only negative I could see here is that premiums might go up. You might see an across-the-board premium increase on jiu-jitsu schools, rock climbing, gyms, et cetera, because now these carriers are going to be like, we need to totally change our risk profile. We need to add more to our premiums to cover all the money we're going to have to pay out now in the future.
I agree with that. And I think that is an issue. I wonder how much premiums are going to raise up. But also, I'm not going to let Rener off the hook.
I don't know why all the hate for Gracie, because at the end of the day, he didn't give an opinion about what the legal ramifications are of what happened. All he did was break down for a jury what the instructor did wrong and what the instructor should have done. But it's the lawyers who are making this argument. The lawyers are the ones who are, opposing the summary judgment motions. They're the ones who are arguing gross negligence. All Rener did was say, look, I'm an experienced practitioner. This is the way it should have been done, and this is the way it was done. And because of that, there was some level of negligence here. But it's not him who's arguing whether it's gross negligence, whether a waiver should be thrown out. So I don't think he deserves all of the hate he's getting. I think he did his job to break it down. I think he did a very good job, right? But it's really the lawyers who went in there and made the arguments that people don't like, not, Mr. Gracie.
I disagree. Here's where we disagree. Here's my take. I agree with everything you just said about the breakdown and the video and everything. I have no problem if he had just explained that. Let's talk about a few things that he said that I don't think are honest. I think it's dishonest, and I wonder if you would agree, and I disagree with him. Number one, he was pretending that there was some industry standard about black belts rolling with white belts and separating the classes so that white belts and black belts didn't roll together. Have you ever faced that in any of the places you go?
I mean, look, I think that's absolutely untrue based on my personal experience, right? As a jiu-jitsu practitioner, and I trained a lot. I trained with you in Texas at University of Texas. I trained, at several schools in Texas. I've trained at 3 or 4 schools in, LA, a Machado school, a Gracie school. I trained with Eddie Bravo. But I think it's absolutely untrue that black belts and white belts get separated. I've never been to a school where even on your first day, if you want to in live rolling roll with a black belt, you can't. Usually in those situations, the black belts will go really easy on you. I've rolled with brand new students and I'm a purple belt all the time. And there's no rule that prevented me. Sometimes they'll separate classes where there's like basic and advanced, where it's like white belts and blue belts. And then, you may have a class that's purple belt and higher, but then there'll also be open mat days where everyone can roll together and there's no restriction. So I just think that's a fantasy. I think it's a fiction.
I agree. So that's number one. I don't think is true. Number two, and relatedly, this is the craziest part. He said, in general, black belt's the industry standard. And again, that is talk where you're talking about legal stuff. You see what I'm saying? That really does apply to lawsuits and really does sink into the jury's mind when you talk about industry standards. But what he said was that it's an industry standard, or that it's regular occurrence, or he does it in his gym maybe. But he said it was an industry standard, but that the black belts don't generally practice moves on white belts, that the instructors don't practice moves on lower belts that they haven't taught that lower belt. And that to me is absolutely crazy, bananas, impossible. It's not only not true, it's impossible. I couldn't even think of how to only roll with the white belt on techniques that I've taught them. That's just.
Well, if you think about it, that's impossible, because what do you do the first day you roll with a white belt when they know nothing? You just lay there like a dead fish and don't do anything.
Yeah, it's crazy. So that right. We agree, untrue if that's was ever said.
Yeah.
And then he said that this was a high risk move, is what he was saying. And basically he was kind of using the ins to say what he did, but basically he was saying it's a high risk move. I would not call this as the Leo Vieira roll, is pretty much what it's called, a front roll back take. Basically, I would not call this move in any form a high risk move if you told me about it before. And so when you say it's a high risk move, I've never seen someone really hurt on a front roll back take of any kind. Would you agree with me?
I mean, look, when you first told me about this, before I went and looked into it, I was thinking maybe he stacked them, right? Because you see in gyms all the time, people are in guard, they get frustrated, and they start stacking someone. And then I saw the video, and I agree with you on all those things, but I still think it comes down to, at the end of the day, he said, look, this is the proper way to do the move, which is, you do it over, under the arms. You don't tie up the arms, right? The black belt, you had the experience to know that, and he did it improperly. It put the student in unnecessary risk, and the jury, who is not experienced in jiu-jitsu, agreed. But I don't think he's a bad guy for doing that. I don't think anything he said about the technique itself was inaccurate, right?
I would agree about the technique. But
right.
Here's the thing of when I rolled, and it kind of tied in what we said before,
Sure.
Which I think, again, I can only speak for myself, but to be clear for anybody, I roll with many, many belt levels from white to black 3 times a week, every week, unless I'm injured, which was maybe 6 months maximum and almost never. But for now over 15 years straight, almost no breaks. I roll with these people. I'm in this community. I've trained at least over 30 gyms, you know what I'm saying, with hundreds of black belts. I agree when you broke it down, what caused this injury? Exactly what Rener said. But for me as a black belt to be doing that move where I don't have the over under, but I do have his arm trapped. When I look at that and I see he chose that, to me, I would never put it in my brain that, that black belt should have known or even could have known that move would result in any increase in risk over any of the other moves.
I don't think anyone's disagreeing that the mechanics of how he was injured was because of where the arm position was. And I don't think there probably was any defense testimony that said that. I think what probably they were saying is this just isn't negligence. This isn't, a deviation from the ordinary standard of care. And then they probably challenged the injuries as well. I think we both agree that it was simple negligence. I think we both agree it was an accident, right? It was not rising to the level of an extreme departure. I think, for example, if he stacked him and broke his neck, that would be gross negligence. Because a black belt in jiu-jitsu should know you can't stack people because you could injure their neck. Or if he did a heel hook and just ripped open his knee and blew out his knee and the guy could never walk again, that's an extreme departure from an ordinary standard of care, because a black belt should know full well that a heel hook's dangerous. A black belt should know you can't, hit it too hard. right? And, that would be gross negligence. So we agree, me and you agree, that this, in our opinion, is ordinary negligence. However, like I said before, when you're adjusting these cases, right, and when you're determining whether or not this verdict was a just and fair verdict, you have to understand people just don't have the knowledge we have. People just haven't experienced that. They are not in a position to opine on whether or not what Rener said is accurate or inaccurate, whether this was dangerous or not dangerous. And you have to understand the risk profile as an adjuster and pay the money, because there is a risk that the jury is going to find gross negligence because the injury is so severe. So I don't think we're disagreeing on anything.
No, I well said, and I agree with that. And let me get to one last thing I think I want to call Rener to task on, and
Sure.
kind of not even call him to task on.
Let's get him on your podcast, man. Let's do it.
I don't know the man. He's a way better practitioner than me. Let's just put that out there. I don't think I'm even near in the league as Rener. But what I would say is I do know certain things. And the problem I had is at the end of his video, he kind of is like, look, it's no big deal. The waivers work, except we don't know if the waivers work. Because in this particular circumstance where we're saying it's simple negligence and this guy got a waiver, the waiver didn't work, right? And so there's no answer there. The second thing he said was, this is such an individual thing where, and again, I don't mind him saying where is a catastrophic accident. That's the one thing here that I think me and you can agree is unique about this case, is the quadriplegic nature of this thing.
Like I said, if this was a broken toe, this would never have happened, right? Yeah. The court would have thrown it out, right? Or a jury might not have found negligence even if the court let it go to a jury trial. Because really, people get emotional about it. I know you have a lot of trial experience, and I've done, a lot of trials as well. And I can tell you the results in my trials have just as much to do with how my client presents and how hurt they are than the facts of how the accident occurred. I've had some really sketchy liability cases get really great verdicts, and I've had some really great liability cases get really sketchy verdicts.
100%. And what I'll say is, I'm only calling Rener to task on his breakdown because I think it's dangerous for the public to misunderstand exactly what you're saying. This is individual. This is a unique thing because of the severity of the damages. But what Rener says, which is like, this is a unique case because, black belt instructors don't usually roll with white belts. And he went down this whole line of things that do actually happen and are not unique at all. There's no uniqueness.
This stuff happens every single day. I guarantee you today, at 100 jiu-jitsu schools across the country, a black belt is going to injure someone by accident. It's just going to happen every single day. That adjuster probably got fired, is my guess.
Well, here's my thing. Rener did, if it wasn't Rener, it would be somebody else. There is no case where you can't find an expert who's willing to maybe exaggerate a little or kind of go a little on what the industry standard is or something, who will say that stuff for $100,000 in a court. If it wasn't Rener, it would be somebody. Would you agree with me? You don't even
need someone who's going to compromise their morals. It's that this is such a subjective situation.
I think you could be right. What I would say is I don't think you're right, because what I see is he was saying what was normal practice and not just at his place, what was normal practice and what was an industry standard. And again, when you get those things, that's not subjective to me. That's an objective thing. I can walk into any school tonight and check if that's a standard. Any school, pick a school.
So, but I kind of like, it could be in jiu-jitsu that all the people Rener hangs out with have their system of what they think is the standard of practice. And then you have the majority of schools that just don't feel like that. And I'm not, like I said, I'm not.
I don't think so. I can tell you, I don't care. I don't believe that. Then at some point you got to stop and say, stop. This is not an industry standard. That is not what they actually cost. You can go into court and say, that's what I think they're worth. That's what I charge, whatever. But the minute you start even hinting that this is an industry standard, then you got to show me 2 or 3 examples. And I'd like to hear that. Rener, if you want to give me
a big country, my friend, there's 2 or 3 examples of everything you can think of.
But Hinner doesn't know them.
problem.
Hinner does not know them. Hinner does not know them. And the industry standard is a different thing than finding
Sure.
2 or 3 examples. That's an industry standard. And
Yeah.
he's saying the opposite, that everybody I know, including some really big names in jiu-jitsu who are as expertise as him, are saying, no, I've never done that. What is he talking about?
I mean, it really comes down to, though, like I said, all of these things are risks that the insurance carrier should have taken into account and consideration.
What I'd like to end on that's important here to me is I can say Hinner was wrong about his breakdown, but in the end, it doesn't matter, because what you said is the most important part, which is the one thing we can take away is jiu-jitsu instructors don't have anything to fear as long as they have the insurance.
Sure.
Almost any state, unless they're completely really wealthy, in which case get even better insurance. But in almost every state, in almost every court, the only time you're going to get this bad result is if the insurance company doesn't do what they're supposed to do. And even in that case, the instructors, the gym owners, everybody is not the one on the hook. I think that's the most important thing to kind of end on here, which is no matter what Hinner did, no matter what anybody did, no matter what the jury decided, it's just like we can pontificate and talk about, ambulance chasing and all that stuff. But in the end, if the only people who are out of pocket are the people that we are all paying to make sure that money doesn't come out of our pocket, then there's no loss. I just wanted to break down. I really appreciate you helping me to break this down for people to understand that maybe this wasn't as unreasonable, as crazy as it seems.
Yeah. Well, I appreciate it. Thanks for having me on, and hopefully make it out to LA sometime soon.
Dude, you got to pay. Just pay. I'll come. No, it's good. All right, man. Well, you have a good one. It was nice talking with you again, and I'll talk at you later, brother. Have a good one.
You too, man. All right.